Colleen Rice, and she is running for Court of Appeals, District 9, over in Beaumont. It's Tuesday, December 17th. And with me is David Smith, Bob Bagley, and Larry Rogers. So Colleen, thanks for coming in tonight.
Thank you for having me. I appreciate the time.
You bet. And as we discussed a few minutes ago, if you'd like to go ahead and start us off with,
Sure.
with your opening, and then we'll just go around the table.
Okay. My name is Colleen Rice. I was born in Beaumont, Texas, and spent about half of my life there, and went to Catholic high school in Beaumont, and went to college in Atlanta, or actually Decatur, Georgia, which is a suburb of Atlanta, Agnes Scott College, which is a women's college with 500 other women. And it was a wonderful start to my education, but what it really showed me is how conservative I actually am, because it was not a very conservative place at the time, and it certainly is not now. Then I returned to Texas and went to law school at South Texas College of Law. I graduated from there in 1995 and met my husband there, and we got married shortly after taking the bar exam in March of 1996. And as soon as we passed the bar, we both started practicing law. We also shortly thereafter started a family, and we now have 4 children, ages 23, 21, 18, and 13. 1 daughter and 3 sons. And so we've had a busy growing family, and then busy law practices. So we've managed to balance all of that. Moved shortly after graduating from law school, we moved back to Montgomery County, where his folks were from, and practiced law with his father. Hence, the practice was Rice and Rice, BC, which is still open today. So I spent a lot of time focusing on family and focusing on law, and kind of balanced and juggled that while the kids were younger. But the past about 12 years or so, I've been practicing much more heavily. And I spent a lot of time doing mostly civil work. So that led me to some appointments in the courts involving family law, some civil, and a lot of probate. And I sort of fell in love with the area of guardianship law. And about 2.5 years ago, I was approached by Judge Claudia Laird to take over the staff attorney and court investigator position being vacated by Judge Kristen Mays. And I discerned and decided that that would be a great way to kind of get a little bit of a change of venue for my practice. And I'm glad I did. I have loved what I've been doing in her court. So fast forward to the past couple of months, and rumors were going around about Chief Justice Steve McKeithen retiring from the bench. And I discerned that I wanted to reach out and see if maybe a run for this position would be a good fit for me. So in doing so, I've really had to kind of stop and think and pray about my abilities and my family's situation and the need for a great Chief Justice to take his step, to fill his shoes. And I really feel strongly that I'm the best candidate in the field for this position. I have a lot to offer, a lot of legal knowledge, a lot of personal attributes that will be beneficial in the position of Chief Justice, and also mostly a passion for the law, a dedication to my work. I'm sort of a perfectionist. I don't ever really get there, as none of us really do. But I think that helps me to do good work, which has been recognized. So my goals in running for this position are to continue to do that. I love what I'm doing at County Court at Law No. 2. But I see this as a higher calling, and there's a real need for a good, strong Chief Justice on the bench. And I'm willing to take that leap if the voters would like me to.
All right, great, thank you. Appreciate that. Okay, so a lot of your experience, of course, just kind of looking through your answers, civil litigation, probate, as you talked about, some appellate. What about criminal cases, and how much of the appeals court deals with that, and what's your experience along that line?
I mean, of course, I went to law school and we're all required to take criminal law. So I did well in courses, and I really have not done any criminal law since then, sort of by choice. Our practice was based around sort of what my father-in-law had been doing and what we were most interested in, and also in raising a family. So just for a lot of reasons, we kind of decided to specialize in civil law and not in criminal law. So I really don't have a lot of practice in criminal law.
Mm-hmm.
However, you know, I'm pretty confident that with a little bit of time to get up to speed, I'm not going to have any problems making decisions regarding criminal cases. You know, it's all based on the code of criminal procedure and the penal code, and reviewing what the judges have done. So, you know, ideally it'd be best if someone had experience in every single type of law that comes before the Court of Appeals. None of us do. So, yes, criminal and civil cases will be heard. So the court hears all the cases that are appealed from all of the county courts of law and all of the district courts. So that's criminal and civil. And I'm not sure what the breakdown is, but I think it's close to 50-50.
Okay. Thanks, Dave.
Yeah. So I know Agnes Scott. I went to Georgia Tech.
Oh, wow.
Yeah. My roommate would say Decatur instead of Decatur. He's from New Jersey. But, so, you know, we've, you know, there's a group of visiting judges who float around the
Yes.
state. And I guess the slang is called rule and run. And so, what do you think about judges passing off controversial cases to visiting judges? We've had that with Toma.
Oh.
What do you think? Is that
Well,
fair to the voters of Texas?
a lot of times I think that visiting judges are brought in when judges need to recuse themselves. And I haven't seen any instances of, or where I've been suspicious that a judge was passing off a case to a visiting judge just to avoid ruling on an issue. I think it reflects poorly on that judge if that's the case, but they do have the discretion to do that. I admire the visiting judges who are willing to go out into the communities and fill in for other judges, because without them, you know, it would slow down the system. It costs the taxpayers a lot of money. Trying to fill those positions, it would probably eventually mean more courts. But I agree with you that that's really not fair to the voters if that's the judge's intention. I don't know that the judges would ever admit that, but maybe people may have suspicions.
Could you explain to the people that will be seeing this and to us, explain the system of the appellate courts? So, starting from, let's say I didn't like the decision that the court made here.
Okay.
So then what happens?
Well, if you don't like the decision that a trial court made during your trial, and errors were preserved for appeal, then you have the ability to appeal that ruling if it's a final judgment based on disagreement with the final judgment. There are also ways to appeal it during the pendency of your case if there are procedural errors that qualify, such as you may need a mandamus if you disagree with the judge's ruling because it's arbitrary and there's irreparable harm. There are also some other ways that you can appeal. So once you get there, you have to file a notice of appeal with the trial court. So if you were having a case heard in Montgomery County, it would be either the district clerk or the county clerk, wherever your court requires. You'd file your notice there. And the system deems that notice appropriate even if you accidentally, or your counsel accidentally files that with the appellate court. And once that is filed, the appellate court is on notice that you're going to appeal. The next steps are that you or your counsel are required to procure and pay for the transcript from the court reporter, if there was one made. or probably to send the file from the clerk's office to the appellate court. So there's some time built in for that. If there's no emergency, and there's only some specific times that you can get a quicker hearing, then these steps are followed. If it is an emergency type hearing, then you have less time to do that, of course. Then the next thing is that you, or your counsel for you could represent yourself, but I'm just assuming you have counsel, would file an appellate brief, briefing the reasons why you feel that you were procedurally harmed during your case. And so if you just disagree with something, you're probably not going to be victorious on appeal. You need to show where there was error that should be reversed to be able to have either the judgment overturned or the case remanded back to the trial court to be reheard. And of course, your opponent will have an opportunity to respond before the appellate court reviews that. And after your opponent responds, you get an opportunity again to respond to his or her response. Then the appellate court will take a look at it. Very rarely do they ask for oral arguments, but that is possible.
And that, there's what, 10 counties that's involved?
10 counties, yes, sir.
And so that's going to require traveling? Do you do it all in
Well,
Beaumont?
the court meets in Beaumont. I've heard that they do also sometimes meet here in Montgomery County, but I don't know what their internal procedures are for determining where they're going to meet. So it would involve travel. Fortunately for me, I have family there, so I already have 2 places to land.
So mainly it would be heard, all the appeals would be made in Beaumont.
For the majority, I anticipate if I am elected to Chief Justice that I will be there from Monday to Friday, full working hours. And then, of course, there's always ways to communicate electronically. But
Okay.
I intend to have to relocate during the week.
All right. Thank you.
I'm going to tap into his. You mentioned that during this process that you may have to get the records, pay for the records to be sent,
Yes,
To-
the person appealing would have to do that.
right? With what we have in the courts today and with the modernization, do we really need to have written documents instead of electronic? That they can, and if so, and if we're using electronic documentation, then there shouldn't be any charge for it.
Well, I think we're talking about 2 different areas. First, there's the clerk's record, which is any piece of paper that is filed in the case. And then there's the court reporter's record, which is the transcription of anything that happened in an oral hearing. So you will be required to send both of those. And unfortunately, they are all electronic, but the clerk of the appellate court will want a certified copy of the clerk's record, where our county or district clerk has to produce that so that it can be sent, and they send it directly to them. And likewise, on the other side with the clerk, the court reporter's record, the court reporter takes down notes during the trial, but they have to be transcribed into the full transcript. And so he or she will have to do that, and they do separately charge a fee. That's separate. So yes, it is expensive, unfortunately, and it can be burdensome, and it could probably stop some people from appealing. But I don't see how the systems would ever change to allow an unofficial transcript or an unofficial clerk's record, or just sending of digital documents over to be sufficient because of the sanctity of what's happened at the trial level being preserved. You know, when judgments are appealed from the Justice of the Peace courts to, and they actually come to our court, County Court at Law number 2, they're heard de novo and there's no record. But in this case, everything that happened during the trial is what is being examined by the appellate court, or, you know, you're pointing out errors A, B, and C. And if that's not a record that is really like rubber stamped by the clerk or by the court reporter as honest and true, it would probably lead to some poor decision making and unfairness in the system.
But we have electronic communications, even within the military, that are secure, that cannot be, you can't adjust them, you can't do anything to it. why cannot we use some of that technology?
No, I'm not actually sure that the clerk can't do that now or doesn't do that, but they still have to process and certify that record. So it may be something that's coming. People have talked about court reporters being replaced by recorders and just, electronic recording. But I don't know that that will ever actually take effect.
I'm not against the transcripts, and I'm not against the actual report being typed out. I'm just, like you said, it's costly
It is costly.
if you're contesting it, and if you really feel that you've been wrongly judged in a case, but you can't go forward because of finances, then you're just stuck.
There could be paupers affidavits involved if you qualify as indigent.
Okay,
So that may help some, but not the hardworking man who makes a decent living, but
Right.
it would be extraordinarily expensive for him or her
right,
to send that transcript. So
Okay.
it is a barrier, unfortunately.
okay, thank you.
Shifting gears a little bit, in your opening, you mentioned you found out how much of a conservative you are when you went to school, and then also you did that on your opening as far as your bio is concerned. What does the word, we hear it all the time from candidates, what does the word conservative mean to you?
Twofold, and I think I'm conservative on both avenues. And the first is morally. I'm definitely a conservative person. I believe I'm pro-life. I recognize the sanctity of all lives. I am for limited government. I really think we need, the government does not need to be involved unless it affects the health and safety and welfare of being, of the human beings being governed. I believe that the state should be left to determine everything that the Constitution and the Declaration of Rights didn't set forth that should be determined by the United States. Then on the other hand, I'm a conservative in my interpretation of the law. And I believe that the laws need to be respected for the words that they say, and that we shouldn't, especially the Constitution and the Declaration of Independence, we shouldn't be pushing them one way or the other to suit our personal whims and the attitudes of society of the day.
What about, you mentioned the sanctity of all life. Do you believe in capital punishment?
I do believe in capital punishment as a necessity on the legal side. And for years, I've really been questioning that recently, because I think I've always been pro-life, but I do see that mistakes are made even when capital punishment is involved, even with all the stop checks we have involved. So it makes me hesitate to want to like the death penalty, but I know that it's a necessary evil.
Okay. Dave?
So, DA's has been talking about the increase in felony violence of the county. We recently had the court run out of money for fighting lawyers for criminal.
Right.
So what's going on? And in that reply, can you work in what role the judges play in
Well,
helping solve this problem?
I really, the first thing that jumps into my mind is probably drug use is leading to a lot of crimes. And then also mental health. We have a mental health crisis, and I see it a lot in my job as court investigator, because a lot of families who have loved ones with mental health issues are desperate for help, and they turn to the idea of guardianship when they hear about it, but then it's really not a great fit. It's only a good fit for a few that actually aren't able to take care of their activities of daily living because of mental health issues. So I think we really, as a society, need to tackle mental health, and we need to try to tackle the drug abuse problem. I also think that our society has become more and more loose, and the family unit is not nearly as important as it has been. And because people don't have role models and support systems, and they may not have had great parents, just perpetuates a lot of bad decision-making. And unfortunately, that falls on the counties, which means more felons involved, means more attorneys involved, and we need to get to the root of the problem, or it's going to just keep continuing to grow.
In your opening on the questionnaire, I presume this is when you were active in law practice, which would have been before 2017. She honed her skills managing business and law practice better. She often accepted a multitude of appointments by judges to act as attorney ad litem, however you say that, guardian ad litem, and amicus attorney. Explain what that means.
Okay, so many years ago I got on the list in our county, as attorneys can, to be qualified to take appointments from different courts. And so I did so for the family law courts as amicus attorney and attorney ad litem for children. And then, and there's a difference between those two, that attorney ad litem is someone who acts on behalf of someone and can be their lawyer, but they're appointed by the court. The amicus attorney is supposed to be the friend to the court. Your client is not the minor child, your client is actually the court, and you're representing to the court what's in that child's best interest. Sometimes those are fascinating cases. And then also in the probate world, I was the attorney ad litem and the guardian ad litem attorney, often appointed on guardianship cases. And those differences were that the guardian ad litem, also sort of like the amicus attorney, recommends to the court what's in the best interest of the proposed ward, like somebody who's going to be put under guardianship. Usually those cases were when the proposed ward was either being exploited, but couldn't voice for themselves their clear, safe opinions, or if the proposed ward is like objecting to guardianship, and in that case the attorney ad litem has to do what they want them to do, but the guardian ad litem has to do what's best for them. And then I was also appointed on several cases that were related to like tax law, tax cases. So through those appointments, I started working for the judges in the capacities that they would appoint. And then I also became appointed as a guardian for several different people, which is not a legal position at all, but it's a position of trust because you have to qualify to do so and report to the court and make the person's personal decisions, and in some cases their financial decisions, and manage their estates.
Okay. And the judge, McKeithen, was that his name?
Chief Justice McKeithen, yes, sir.
And so, did he retire? Is that what?
He is retiring next year.
Okay. All right.
We've had an issue in Montgomery County over the years with judges specifically not showing up for work. And the offices being closed, lawyers can't get to them on a Monday or on a Friday. And then many times throughout the week, their courthouse is closed. And yes, they have some of their staff there, but there's no way of actually finding out how much time they're actually working. For this position, it's not so much the time that you're going to be spending in the court. Most of your time is going to be spent reviewing the cases and reading.
Right.
And so it's really cut back on the need for you to actually be there, unless you're having meetings with the full body with the other judges. How do you feel about working from home? Do you feel that working from home you'll be more productive or less productive?
Well, I really have tried not to think about that, because I really think if I'm elected Chief Justice, I want to pour my all into it. So I'm planning to be there every day out of respect for the other justices. because this is a little bit of a unique position because you're not the only judge.
Right.
And I know they may have their own work habits. I've heard that Justice Horton is in the office from 8 to 5 at least every single day. I know they all work hard. So if that's something that we all agree on being acceptable, and if one of them wants to do that, that's fine. I know for me, as I said, I'm sort of a perfectionist. I'm gonna be there a lot, especially getting my feet wet, getting acclimated and feeling really confident, which probably will take a little bit of time. But if it's something that's feasible and it doesn't stop anything related to the quality of the work and everybody wants to do that, then I'd be on board, especially with the travel. But it won't be a problem for me to travel there and to be there. I can set up camp. I could be there tomorrow if I needed to. So.
Do you know what the staffing is for that office?
I do. So I've heard, I haven't actually set foot in the office, but I've heard that each justice, there's 4 justices, that each justice has 2 staff attorneys and an assistant. And then, of course, the clerk is a separate portion of that office. And I'm not sure what her staff looks like, but I think she's at least got an assistant. And then when they rule on cases, they rule as in 3s. There's always one that's left out. So of the all of the districts in Texas, 3 is the minimum number of justices, but we have 4 in this district. So there will always be one who's not included in the ruling unless they rule them wrong.
David, go ahead.
Yeah. I've been on two jury and 2 trials. One was family, civil, one was criminal. Difficult court to sit in with all the heartache and families. So we have an agency, Child Protective Services, and it seems to be controversial.
Yes.
So can you talk a little bit about that, and then what are your thoughts on making it less controversial?
Okay. I haven't spent a lot of time working with Child Protective Services, but I've called them several times regarding people in our court that have, or issues that have come up related to that, and records. And I know that right now, well, first of all, I think that they all probably try to do a good job, but I know there have been a lot of cases in the news in the past few years where they've taken children without people feeling that there was a real necessity to do so and infringing parents' rights. And I completely disagree with the process of removal of a child from a family situation without any notice to the parents. I know that all happens really quickly and hopefully only in the most urgent and dire circumstances when a child's welfare is at risk. But I would hope that the legislature would address these issues that are such concerns to the people and to put in place maybe some better rules about the procedures of notification of the parents, if they can be notified. As far as the Child Protective Services goes and Adult Protective Services, because I see so much of that on my end with guardianship in our court, there are so many people out there being abused of all ages, and we have a real necessity for agencies like this to be doing this job. I just think that there may need to be a little bit more clarification in the law regarding the burden before removing children and the notice to parents and families. And then I think that they actually, part of me wants them to have a harder time grabbing someone for safety, but I also think that they also are underpowered by the legislature to be able to change some circumstances. And those are things I'm seeing that we see pretty frequently in our court and these are for adults, but adults that have disabilities. So they have intellectual disabilities and they can't, they're very, very much like children, and they're actually called wards, like they're actually minors under the law, where they can't make their own decisions and they're being exploited. And it happens just too frequently. And I think what we see is only the tip of the iceberg. So I completely respect the concerns about child protective services and families whose children are taken maybe without cause. But I think that we have to put procedures in place so that that can happen if doctors or educators are reporting abuse, that there can be some quick remedy. But even in the most dire circumstances, I don't think that children should be taken from their parents without notice.
One of our questions was, what amount of indigent defense is appropriate for the state of Montgomery County and why? And in your answer, you said Montgomery County should allocate this maximum, the maximum allowed, so defendants are afforded their rights to fair trial, to fair trials. Do you think that's being done now in Montgomery County?
I do think that's being done, because I work for a civil court, and I know that the defense budget comes before our civil court budget. I do think it's being done. I just think that the numbers are growing so rapidly that may be where they're running into problems in indigent defense, criminal defense. We have a really growing county, and the state of Texas is really growing. So I think that we all need to work, I'm speaking for myself as part of the government now, we all need to make sure that we're watching and doing everything we can to save the taxpayers' money and to be as efficient as possible. And that's something I want to carry over when if I become Chief Justice, is to make sure that we're as efficient as possible so that we're prepared for all of those emergency hearings and to take on the cases and not have a backlog.
And if you do become Chief Justice, will you apparently have not practiced in the law practice with your husband and your father-in-law for quite some time. I would assume you would have those duties there.
Right. Actually, I hadn't thought much about it, but you're right. It will not be easy to leave the court because I love what I'm doing, but I'll be able to wrap up the cases that I'm working on, and Judge can halt assigning me on cases just as I leave. So I have nothing left that's not tidied up from my law practice. It's been over 2 years, not quite 2.5 years. So I had to I had to step out of all of those cases already.
Okay, Bob.
Civil asset forfeiture. I liked your responses. We've had a number of problems within our county with civil asset forfeiture being mishandled and the lack of due process for the individuals. What's your feeling on due process?
I don't think that there's enough due process in the current procedures for civil forfeiture, and I think I would like to change that, but the avenue would be through the legislature.
So what would your suggestion be to the legislature to do that?
My suggestion would be to require a burden of proof of guilt before any forfeiture takes place. I know we all want, we don't want people to benefit from their bad deeds, but I think it's kind of putting the cart before the horse, and a lot of times the punishment is greater than the criminal punishment would be. There's a recent case where some sort of vehicle was going to be taken. It was about a $40,000 vehicle, and the punishment, the monetary fine for the punishment was $2,500. So that just doesn't make economic sense, and it really is a violation of due process and constitutional rights. And I think that there's a way to make this happen without being infringing on people's rights, especially because the people that are implementing the forfeiture, their departments benefit from that, and they've got an incentive to do so, and that's just not something that any citizen should agree with.
From what I read, you don't believe in legislating from the bench. However, there's nothing that would stop you as a judge from making a suggestion, writing writing the text for a law
Right.
and sending it to the legislature to have them process it.
The only thing that would stop me is I wouldn't do it during my hours working as Chief Justice. I would do it on my own time, but you're right. And judges have an eye for what the problems are, and I think that more of them should be proposing legislature. I know Judge Laird has worked on a lot of legislature, and it hasn't always gotten picked up. It's very frustrating. I've gotten help review a lot of that with her, and you get so wed to it. It's disappointing when it doesn't get picked up, but it doesn't mean it can't be proposed again later.
Didn't she bring that forward, something forward to Congress? And
Well, to the state legislature.
Or to the state
Yes,
legislature.
yes, and several things recently, but the most recent session didn't, none of it worked. But
try again.
yeah, we will. Well, there've been a lot of changes in guardianship law. And that's another thing, another reason I'll be great as Chief Justice, is that no one on the bench currently, and none of my opponents have any experience with or have very much experience with probate law, and especially with guardianship. And guardianship is for adults who are incapacitated. So we may have 18-year-olds to, you know, somebody who's 102, different afflictions. And they're really the weakest among us because we see a lot of exploitation, and their constitutional rights are usually all taken from them and assigned to someone else. So there's a lot of follow-up. The cases stay open so that they can be monitored to make sure that the rights are being protected and that the decisions are being made wisely. And people think that will never happen to me. Well, I can tell you, I've seen cases, any one of us can be put under guardianship. You can have the best powers of attorney written and everything in place, and maybe your kids disagree on something and they start battling it out, and one takes you to get new estate planning when you've had Alzheimer's for 5 years, and then bingo, you find yourself in the probate court, and things can get really messy, and it's just sad.
Out of, just looking at this map on the Court of Appeals districts here, in the Ninth Court, how many cases are there in general? I'm not going to hold you to an exact number. And how many of those are appealed? What goes to the appellate court typically?
I was looking
percent-wise?
recently, and they had about, I think the average was 400 to 500 cases, and they make a ruling on all of them, even if they're not like procedurally correct for being heard, that they have to issue a ruling on it. But I don't know what the total number of cases from all 10 of those counties is. And I really should have looked, I'm anxious to see what that is, to see what percentage actually gets appealed.
Right,
Not quite
right.
sure.
Okay, no worries. Okay. We got about 5 minutes, 7 minutes, I think, enough to go around.
So, we talked about the problem of judges showing up, put an ankle bracelet on, narrow the scope, keep them in the office, but, so how do we judge a successful appeals court judge? It's all paperwork, basically. It's review of paper document.
Well, all of the opinions are online, so you can.
But as a layman, as a layman.
As a layman, yes, you probably wouldn't be perusing
Yeah,
those
I'm
opinions.
perusing that. Most of us would think the ankle bracelet would.
I don't know how you would actually judge them unless it was just word of mouth, and maybe through the legal community. But I have to say, I really haven't heard anything negative about our current court. So I'm not running to fix anything. It's just that there's going to be a vacancy, and we want someone very well qualified to be in that spot because a lot hinges on this. In 2018, there were a whole lot of new judges appointed to appellate courts around the state, and a lot of those are liberals. So those appeals are going to be trickling up to the Supreme Court and to the Court of Criminal Appeals. And if they don't have good, solid, conservative rulings that follow the law and the Constitution and protect rights, they're not going to have they're not going to have the law they need to rely on when they make their opinions, which are going to affect everyone. So it's important. But as far as, I think I forgot, Mr. Bagley, to answer your question about judges not being in their offices. And out of respect for the judges we have, they do a lot that's behind the scenes, even when they're not on the bench or in their office, because of the, they have their judge meetings, and they have to look at the accounting for the county and those sorts of things. So they do have a lot of other jobs, but I'm sure that there are some that are maybe playing hooky. And that is a problem, because there's a lot of work to be done. I don't intend to do that.
You done? Dave? Okay, I'm out too. All right, while we wrap it up, we're getting close anyway, so.
Okay.
If you would like to take, again, up to 5 minutes in your closing, then we'll call a wrap.
If any of you have any more questions, I'd be happy to give you the time. It's gone fast. Okay. Well, I just hope you all give me a strong consideration for your endorsement, which is very appreciated. I have a clean background. If anyone has anything negative to say about me or my family, I'd like to hear it. We just kind of live an honest life with our nose to the grindstone, trying to keep kids doing what they're supposed to do and getting our work done well. One of the reasons that I'm seeking this bench is that I was encouraged by several very trusted friends who know me and know my work and have seen the work of some others, and said, you would be awesome for this because you're hardworking, you're bright. Even if you don't know something, you're going to research to the ends of the earth to figure it out and get your feet wet, and you're organized and dedicated. So I am excited about the prospect of running. I've met so many really interesting, wonderful people already that it's been good, because while I have real strong political views, I haven't been very, very involved in local politics. But now I'm out there and I'm loving it. So thank you for your time. I appreciate it.
Thank you for coming in. Appreciate it. Good luck on your campaign.
Thank you.
All right.
Have a Merry Christmas.
You too.
Yes.
Merry Christmas.